Some argue that this is growing government, that we don't need it, and that it's too expensive. These arguments must fail. There is no price tag on providing litigants with justice. In fact, the West Virginia Constitution contemplates the creation of this court, the very check and balance that West Virginia too long has lacked. In 2019, the United States Chamber surveyed West Virginia's legal climate, where West Virginia ranked 45, up 5 spots from previous years. This poll was of in-house counsel with experience litigating in West Virginia. And one of the factors keeping West Virginia at the bottom was lack of full appellate review. It's time to change that. Each of you ran for office to continue to improve the state we love. This is your time. The United States Chamber of Commerce urges each of you to support Senate Bill 275, to tell the world once and for all that West Virginia is a wonderful place to live, work, and play. And whether you live here or want to move here, you will have access to a fair and predictable court system. Thank you, Mr. Chairman, and thank you, members of this committee.
Thank you, Ms. Waltz. Again, I didn't introduce myself. I'm More Capito. Sorry about that. Andy Walters, followed by Anthony Magistro. Mr. Walters.
Thank you. I'm Andy Walters. I'm the Secretary-Treasurer for the West Virginia AFL-CIO. We represent 575 union locals and 75,000 members, and we oppose Senate Bill 275. Many rights were taken away from injured workers when workers' compensation system was privatized. This bill further strips away the rights of injured workers by eliminating the office of judges. And it slows down the system, putting it in the hands of political appointees. Ultimately, this will put financial and health burdens on our injured parties. Creating this additional layer of government harms the average West Virginian by making workers' compensation cases even longer and will make more expensive to appeal. No one has explained the new court would efficiently absorb more than 2,000 cases appealed each year by the system, but yet this bill seeks to remove the funding that supports the current mechanism in which these cases are heard. We are afraid that another attempt to support big money corporations whose interests can afford to drag out workers' compensation cases to starve out working families. And meanwhile, this legislature will be adding another unnecessary layer of big government at the taxpayer's expense, which seems to be the most current trend. Thank you.
Thank you very much, Mr. Walters. Anthony Magistro, followed by Beth Kavitz. Thank you very much, Mr. Walters.
Good morning, Mr. Chairman. Thank you for and members of the committee. Thank you for allowing me to appear here today. My name is Anthony Magistro. I'm the legislative chair for the West Virginia Association for Justice. And as in the past, we oppose the creation of an intermediate court of appeals as an unnecessary expense for our state, both in terms of its effect on litigants and its effect on the expenditures of our state's finances. I'm going to address just a couple of aspects of that. And first aspect I want to address is that the proponents who claim that West Virginia doesn't have an automatic right of appeal simply are wrong. The West Virginia Supreme Court of Appeals, our state's highest court, used to have discretionary appeals, and they would decide whether or not they were going to take a case. That is where the push for the Intermediate Court of Appeals first started. However, now, as of 2010, to address that concern, the West Virginia Supreme Court implemented new rules that changed West Virginia from a state where appeals were discretionary to one where there is an automatic right of appeal. The National Center for State Courts has affirmed that the automatic right of appeal exists in West Virginia. So when you hear from others who say we don't have a right to appeal in West Virginia, they are simply wrong and they're not telling the truth. By any objective standard, every appeal that gets filed with the Supreme Court gets heard and result in a decision on the merits and the claims. Now, the second thing that the proponents of the Intermediate Court of Appeals emphasize is that they don't necessarily get formal decisions in every case. What the Supreme Court does is it has a couple of different ways it renders decisions. One is that it renders a decision, a signed opinion with syllabus points setting forth the law. But in cases where the law is clear and the court is resolving issues of application of facts to law, the Supreme Court enters memorandum decisions.
Please wrap up your remarks, Mr. Magistro.
Those memorandum decisions are precedent that the litigants and the court cites, and they serve the same purposes as the decisions of the Intermediate Court of Appeals will, and those decisions will come from our state's highest court, which will give them even greater precedental effect.
Thank you very much. Beth Kavitz, followed by Samuel Hickman.
Thank you very much.
Ms. Kavitz?
Followed by Samuel Hickman. Ms. Kavitz?
You may be muted if you're speaking, Ms. Kavitz.
My mute button is being cantankerous.
If you're speaking, Ms. Kavitz.
My mute button is being cantankerous.
Guess that most divorces are done pro se, people not having lawyers. I know that Legal Aid of West Virginia before the pandemic ran clinics that did 90 people a month to help them do pro se. Right now, a domestic relations court appeal goes to the circuit court. Pretty easy thing to do. Some courthouses you just go upstairs or next door. If there's an intermediate court, but this bill, as I understand it, takes the appeals from domestic relations court and sends them to one of two intermediate appellate courts. That means a lot of travel. That's a very difficult thing for people. And in addition to the troubles with the pro se people, it's going to be more expensive to hire their lawyers to travel across the state to go to these things. And all this is going to happen during a divorce when people can least afford things. So I would urge you not to have appeals of domestic relations decisions go to the intermediate appellate court, but first to circuit court. Thank you very much.
Thank you, Mr. McMahon. Gary Zuckett, followed by Rebecca McPhail.
Good morning, Mr. Chairman. My name is Emmett Pepper. Gary Zuckett has offered to allow me to speak in his stead, if that's okay.
Please proceed.
Thank you. I am a legislative advocate for Mountain State Justice, and I'm delivering these remarks on behalf of Mountain State Justice and West Virginia Citizen Action Group. And thank you to Mr. Zuckett for allowing me to take his place today. Mountain State Justice is a nonprofit law firm representing low-income people where we work to ensure their access to the civil justice system. And we're able to provide free legal services for those who could not otherwise afford it. Creating an intermediate court of appeals would severely impact these clients' ability to get help and impede our ability to continue to protect their rights. Our efforts to represent thousands of low-income clients who could not otherwise afford to have legal representation would be compromised by the bill. Even if we could be able to provide them legal services, the intermediate court will also impact the case ability to be adjudicated. It will slow the speedy resolution of cases, delaying from finality from 1 to 2 years to something like more like 5 to 8 years. While we are equipped to handle litigation matters, what matters to us is getting resolutions for our clients and get them on their way. Appeals deny our clients and every client that opportunity. Matters on appeal take hundreds of hours more than a typical case. Some examples: in a predatory lending case that went to trial, then appeal, and then was remanded, we spent over 900 hours on the case, and it was resolved after 8 years of litigation. During the pendency of the appeal, our client passed away and was never able to receive the benefits of the closure of her case. A similar case that went to trial but was not appealed took 275 hours of time and was resolved after a couple of years. Even for smaller cases where someone takes out a debt.
Pepper, if you would wrap up your remarks, please.
I will, thank you. In summary, this bill delays the speedy resolution of litigation and creates unnecessary costs on our consumers, our coal miners, and our West Virginians and the companies who do business here. We urge rejection.
Thank you, Mr. Pepper. Rebecca McPhail, followed by Jean Evansmore.
Good morning, Mr. Chairman, members of the committee. My name is Rebecca McPhail, and I'm with the West Virginia Manufacturers Association today, and also representing the West Virginia Business and Industry Council, here to support the adoption of Senate Bill 275. The WVMA represents our state's manufacturing industry, which directly employs more than 47,000 West Virginians with a total jobs impact of over 200,000. While the West Virginia Business and Industry Council consists of more than 60 state trade associations and businesses that represent more than 395,000 West Virginia workers across 26 separate industry sectors. An important factor in attracting and retaining manufacturing business investment for the Mountain State is a consistent, predictable, and stable body of law. Investment and job growth benefits when businesses and industry gain confidence that West Virginia's courts will apply the law consistently throughout the state. As West Virginia works to compete for the reshoring of American manufacturing jobs, opportunities in downstream natural gas and energy development, and as we continue to focus on attracting business investment and jobs to our state, we must do everything in our power to stand out to those who may do business here. It's time for West Virginia to join 41 other states who have some version of an intermediate court of appeals. We hope that the House of Delegates will support Senate Bill 275 and this important step forward for our state's business climate. Thank you, Mr. Chairman.
Thank you, Ms. McPhail. Just a housekeeping note. We're having some technical difficulty with our YouTube stream. We are still streaming live over our system for the House of Delegates, but our YouTube stream has been affected. But that doesn't affect your testimony here today. To all the members, everybody's coming through loud and clear. So, Gene Evansmore, followed by Joseph Cohen.
Good morning.
Good morning.
I appreciate being able to do this. My plan this year was to show up in Charleston about once a week. A friend and I set it up some time ago. Okay. I am hearing over and over about bills that are created to fix a problem that I'm not sure exists. West Virginia is a very poor state. And when I keep hearing about how this is going to affect and bring business and bring people in, and when the opposite is happening, I have to think something about that isn't quite clear. I appreciate the people who showing up and giving their opinions and whatever, and I'm learning one heck of a lot. However, if it ain't broke, don't fix it. Please. If it ain't broke, and I know that's not correct grammar, don't try to fix it. Use this thing called a brain. Think about the money that's going past people who need it. Thank you. We're a poor state. We don't need to do that. We don't need to do what somebody else is doing. It's not going to bring people in. That is a bunch of crap, and y'all know it better than I do. Thank you. Have a great day.
You too, Ms. Evansmore. Thank you for being with us. Joseph Cohen, followed by Julie Archer.
Good morning. My name is Joseph Cohen. I am the Executive Director of the American Civil Liberties Union of West Virginia. I sadly speak in opposition to SB 275. Our organization takes great interest in matters of due process, access to the courts, and the fair, efficient administration of justice. I think it's fair to say that generally we are supportive of additional meaningful opportunities for judicial review. And while there would certainly be competing concerns to balance, on the whole, I would normally expect us to support the establishment of an intermediate appellate court in West Virginia. Nonetheless, the ACLU of West Virginia must oppose SB 275 because it fails to provide access to the proposed immediate appellate court to those litigants who have the most at stake. For some reason, SB 275 specifically excludes criminal defendants from appealing convictions to the proposed intermediate court.
Wow.
Under SB 275, people facing the complete loss of liberty and freedom of movement, sometimes for the rest of their lives, are explicitly denied the right to appeal their cases to the proposed court. Criminal defendants have so much more to lose than civil defendants, and any rational system would ensure that criminal cases had at least as many, if not more, levels of review than civil cases. Yet under SB 275, insurance companies are afforded more protections than people who face being locked in a cage. And big corporations are given more chances to tell their side of the story than children who face being separated from their families. We can draw only one conclusion. SB 275 is not about justice. It is not about due process. It is not about making our system more efficient. SB 275's explicit exclusion of criminal cases belies the bill's true purpose. It is simply a tool to allow parties with deep pockets to draw out litigation as a weapon in cases against those with less resources. As such, I urge you to oppose the bill. And thank you very much.
Thank you, Mr. Cohen. Julie Archer, followed by Samuel White.
Thank you, Mr. Chairman. Can you hear me?
Loud and clear.
Okay, thank you. Good morning. My name is Julie Archer, and I'm here today on behalf of West Virginia Citizens for Clean Elections, a coalition of groups working to advance reforms that strengthen our democracy and and ensure fairness and impartiality in our courts. We urge you to vote no on Senate Bill 275, which would create an intermediate court of appeals. West Virginia is one of 10 states without an active intermediate court because our caseloads don't justify the expense. Total appeals to our Supreme Court have declined nearly 70% over the last 20 years. Senate Bill 275 would create a court that West Virginia simply doesn't need. The millions that would be wasted on this unnecessary court would be better spent on things that help our families and our communities thrive. That money could be used to fix our roads, improve our schools, fund senior and veteran services, and programs to help those who are struggling financially due to the pandemic. However, in addition to our concerns about the state's spending priorities, we are also concerned about the millions that will undoubtedly be spent by special interest groups to elect their preferred candidates to this new court. In West Virginia, we've seen firsthand the impact big money has in judicial elections. Recent Supreme Court elections have seen millions of dollars in spending by powerful special interest groups. Most of this spending was hidden in the shadows because West Virginia's current campaign finance laws allow groups that spend money to influence our elections to hide the identity of their donors. Without increased transparency of this spending, the appearance and reality of even-handed justice is at risk. Special interest groups spending big money on these elections see our Supreme Court as an effective vehicle to further their political, ideological, and financial agendas. This new court wouldn't be any different. Our courts are powerful and they matter. Their rulings impact our health, our freedom, and our bank accounts. Don't let special interests have their way with our courts. Too much is at stake. Vote no on Senate Bill 275. Thank you.
Thank you, Ms. Archer. Samuel White, followed by Rich Holtzapfel.
Thank you, Ms. Archer. Samuel White, followed by Rich Holtzapfel.
Mr. White, if you're speaking, you are on mute.
Thank you, Mr. Chairman. My name is Samuel White, and I am the Legal Services Coordinator for the West Virginia Coalition Against Domestic Violence. I speak today in opposition to this bill. Under this bill, appeals of final orders of family courts must be taken to the Intermediate Court of Appeals instead of to the circuit courts as currently happens under our code. The Intermediate Court of Appeals will split the state into two districts composed of 27 and 28 counties, and hearings of the court can be held in any geographic location deemed convenient for the litigants. Survivors of domestic violence have often fled their abusers, leaving everything they have behind, including their home and vehicle. They often have no resources to travel, even to a neighboring county that the court may deem is convenient. Some have a hard time traveling even to the court in the county where they originally filed their domestic violence protective order or divorce. Passage of this bill makes us concerned that survivors of domestic violence will be unable or unwilling to appeal their cases because their lack of resources make it impossible for them to travel to the place where the court determines is convenient. Further, under our current law, a party who wishes to appeal a domestic violence protective order appeals to the circuit court. The hearing on that appeal must be held within 10 days of the petition for appeal. It seems impossible that a court serving 27 or 28 counties will be able to hear all of these appeals within all of those counties within the time prescribed by code. While the appeal does leave the protective order in effect pending the appeal, delaying the hearings beyond 10 days fails to comply with the requirements of our code and leaves parties to protective orders in limbo about their cases while they await a final hearing. Additionally, requiring appeals to the intermediate court will delay final decisions in divorce and custody proceedings. For these reasons, we ask that you oppose Senate Bill 275 and the creating of the Intermediate Court of Appeals. And Mr. Chairman, I thank you for your time.
Thank you very much, Mr. White. Rich Holtzapfel. I don't know if I got that right, sir, but you are up, and Robin Godfrey is next.
Thank you, Mr. Chairman. You were actually pretty close on the name. Can you hear me okay?
Loud and clear.
All right, thank you. Good morning, everybody. I'm from West Virginia. I live in Scott Depot. I was born in Weirton and had a lot of family that worked in the steel mills. And I was raised in Huntington, though, from about the time I was age 12. I'm a graduate of Marshall and WVU, which basically means my student loan loyalty is evenly divided. When I turned 18, I kind of broke ranks with the majority of my family and the majority of West Virginia, and I registered as a Republican. There wasn't a red wave at the time, maybe a red trickle perhaps, but I was a Republican before it was cool to be one. And the reason I joined the party was because of what it stood for. Ronald Reagan said that the 9 most terrifying words are, "I'm from the government and I'm here to help." And as a Christian, I was pro-life. I own guns, and I believed in smaller government, smaller budgets, and financial responsibility. And so it's against these principles that I weigh Senate Bill 275. And I think we know the numbers just don't justify it. I would never hire somebody to help my son mow the yard if he was doing just fine by himself and didn't need the help. You business owners know you would never hire new employees if your current employees are doing just fine. Our current Supreme Court works hard, but they're able to get the job done. In my opinion, the ICA, and I speak against Senate Bill 275, it goes against the principles that I believe in. We're hiring unnecessary employees, adding another layer of government, making our government bigger, making our budget bigger. And it's almost like watching Freaky Friday when I look at how we are proposing this and who is proposing this to add this layer of unnecessary government to our state. So
if you would wrap up your remarks.
Sure, I'd encourage everyone to come back to our principles. Let's not be rhinos. Let's be financially responsible. Don't expand our government. And let's vote against 275. Thank you, Mr. Chairman.
Thank you very much. Robin Godfrey, followed by Brian Dayton.
Thank you, Mr. Chairman and members of the committee. This is Robin Godfrey. You can hear me okay?
Yes, sir.
Okay, thank you. I'm speaking in opposition to Senate Bill 275. I'm from West Virginia, born and raised, and I've practiced law for 45 years, 5 years at legal aid, and 40 years as a solo lawyer. The bulk of my work was in bankruptcy court and doing family law. I filed over 4,000 bankruptcies. I've done a small amount of civil litigation from the plaintiff's perspective, and I did some criminal defense work. Now, speaking selfishly as a lawyer, looking at this, yeah, I'd like to be a judge on this. It pays good, you get free parking, and I get to wear a robe. But overall, I think this is a bad idea, this bill. Whatever price tag is put on this, I just have to say, I would add a fudge factor and a big one. Have we ever established a new government entity and said, wow, every year the cost of running this thing goes down? But my main objection to this bill is the most important aspect of a court system is resolution. The parties in a dispute need their matter resolved. And there are already plenty enough delays by us lawyers, for starters, by judges, and by circumstances. Adding another layer and costs for the court, especially when the number of appeals the Supreme Court's gone down so markedly, does a real disservice to the public and to litigants. It delays resolution of their disputes. And it doesn't provide clarity. That's the Supreme Court's job. It provides clunkiness. And that's the last thing a judicial system needs. This is a bad idea that costs a lot and adds burden and delay to the people who use the courts, the public, and the litigants. And I can't imagine how it would possibly attract anyone, never mind a business, to consider staying here or locating here. Thank you for this opportunity to speak.
Thank you, Mr. Godfrey. Brian Dayton, followed by Sally Roberts.
Well, thank you, Mr. Chairman, for the opportunity to be here this morning. I'm Brian Dayton, and I'm with the West Virginia Chamber of Commerce. Our members are located in all 55 counties of West Virginia and employ over half of our state's workforce, and they represent every sector of our economy. The West Virginia Chamber is the voice of business in West Virginia. The West Virginia Chamber and its members have long been advocates for the creation of an intermediate appellate court. The Chamber believes that strong appellate review helps create a consistent, predictable, and stable body of law. And strong appellate review boosts confidence that our courts will apply the law consistently throughout the state of West Virginia. An intermediate appellate court would free up the West Virginia Supreme Court of Appeals to dedicate adequate time to consider and write opinions that have a defining impact on law and public policy. One of the components the Chamber finds most intriguing about this bill is how it would assist circuit courts across the state. Chamber members who practice law tell us that many of the circuit courts in West Virginia have a significant backlog that can delay parties' ability to quickly access the courts to resolve disputes. This bill would remedy this by moving family court appeals into the Intermediate Appellate Court, and it would also move appeals from the State Administrative Procedures Act into the new Intermediate Appellate Court. The bill keeps criminal appeals and abuse and neglect cases going straight to the Supreme Court for their appeals, not to deny them an adequate level of review, but to make sure these very important cases reach finality quickly. These components of the bill should provide quicker access to the courts for all parties. 41 states have a version of an Intermediate Court of Appeals, and of the states that do not have one, West Virginia has the largest population by more than 500,000 citizens over the 500,000 citizens over the next most populous state without an Intermediate Appellate Court. In conclusion, in 2009, then Governor Joe Manchin convened the West Virginia Independent Commission on Judicial Reform that was chaired by none other than former U.S. Supreme Court Justice Sandra Day O'Connor. That commission, which included several other prominent and highly respected individuals who are known to many of the people on this Zoom and probably listening in live, they recommended 4 key items, 3 of which have been implemented already. The last is an Intermediate Appellate Court. I would like to applaud the legislature for giving consideration to this very important issue. And Mr. Chairman, thank you for the opportunity to speak today.
Thank you, Mr. Dayton. Sally Roberts, followed by Tom Rode.
Hello, good morning. Before I speak in opposition to SB 275, I would like to thank you, Chairman, once again for opening up this process of public hearing. I appreciate that, and for allowing me to be part of this democratic process. At a time when we will likely be seeing across the board cuts to our state programs, this bill will be adding an additional layer of costs that are not necessary or prudent at this time. It will also have a negative effect on those low or fixed income West Virginians who will find their settlements diminished by the court costs and costs of counsel, and if they can afford it at all, if they can afford counsel at all, or who may not live to see the final judgment if they're elderly, as I am, due to the increased delay caused by an additional layer of adjudication. SB 275 will not serve the needs of our citizens and is unnecessary and not financially prudent at this time, and I urge you to vote against its passage. Thank you.
Thank you so much, Ms. Roberts. Tom Rode, followed by Scott Wyndham.
Hello, can you hear me?
Yes, sir.
Thank you. Thanks for the opportunity to speak today. My name is Tom Rod. I'm speaking from Preston County, where I live. I'm a retired attorney. I spent 12 years working at the West Virginia Supreme Court of Appeals, and I just wanted to give you the benefit of my experience from the inside. I don't think West Virginia needs an Intermediate Court of Appeals. I think our Supreme Court is actually doing a pretty good job, works pretty quickly, and produces pretty good decisions on balance. And really, the only predictable thing that you can say about creating a new court is that it would add a great deal of delay to a lot of cases, because people would get a decision from the Intermediate Court and then they could stop that from going into place for years, probably. So it would allow professional defendants the opportunity to delay, add years, and that gives them a lot of leverage in settling the cases. So I associate myself completely with the remarks of all the folks who said the various reasons why this is not really a good idea. And I urge the legislature to, as it has in the past, look at this issue, but decide this is not something that West Virginia needs at this time, and it really would do a lot of harm to ordinary folks. Thank you.
Thank you, Mr. Rod. Scott Wyndham, followed by Sean Harder.
Thank you, Mr. Chairman and members of the committee. My name is Scott Wyndham. I am a proud courtroom lawyer, and I practice in Ritchie County, where my father and I have an active oil and gas practice. I'm here to ask you to reject Senate Bill 275. William Gladstone famously said that justice delayed is justice denied. I'm here to discuss that delay, and I want to give you an example. One of our oil and gas clients is a retired farmer from here in Ritchie County, sued a multi-billion-dollar out-of-state oil and gas corporation a few years ago. The same company has lawyers from Texas and Pennsylvania and New York, and I was in a hearing with them last week, and they flew their lawyers in for the hearing. Deep pockets. My client is a retired millwright. My clients had a valid claim for the improper deductions of post-production costs and their royalties. It was a simple contracts case. It was a pretty clear case, and it was headed to trial. The West Virginia lawyer called me up and says, we want you to take 25 cents on the dollar. I asked, why would my clients take 25 cents on the dollar? You may be surprised, given prior testimony in this matter, it was not to give my clients a fair shake. Rather, the lawyer told me it was to bury the case in a stack of appeals and my clients would never see their money. Oil and gas litigation is littered with clients who never lived to see their money. The Tawney case, Garrison Tawney died. The Leggett case versus EQT, Patrick Leggett died while these cases were on appeal. Billion-dollar companies are not interested in giving your constituents a fair shake. They want this bill because it's a club that they can beat your constituents into submission. John W. Davis, 1924 presidential candidate from Clarksburg, West Virginia, said it is easier to get your hand into the machine of litigation than it is to pull it out. This intermediate court is nothing more than another cog to grind your constituents into submission, entangle the people of West Virginia in litigation.
Please wrap your remarks.
Please vote no on Senate Bill 275. Thank you.
Thank you, Mr. Wyndham. Sean Harder, followed by Steve Broadwater.
Thank you, Chairman Capito and committee members. I'm an attorney in the state of West Virginia. I've been practicing for 30 years, and the last 28 plus years of that as a workers' compensation attorney. I do nothing but workers' compensation defense. I'm a proud Republican and pro-business person. And I don't have a problem with an intermediate court of appeals per se, the idea, but I would speak against the provisions contained in the bill as they terminate the Workers' Compensation Office of Judges and change our entire workers' compensation process. Our Office of Judges is currently comprised of 34 employees, 11 of whom are chief or administrative law judges. This bill would terminate them. They are people who have extensive experience and knowledge of the workers' compensation process, and we would lose greatly if we lost those people and we didn't have their great decisions to rely upon. They actually render decisions that contain findings of fact and conclusions of law. They are very thorough. It is a very rare instance when you don't know why one of these judges has rendered a decision. They have a support staff that is very knowledgeable and is very good at processing litigation. And if we terminate them, our workers' compensation system will be harmed. We currently have in our system a workers' compensation board of review that actually is made up of 3 very qualified people as well, 2 of whom have practiced in workers' compensation for many years before becoming board members. They currently are the people who decide appeals in workers' comp. So we don't need a court that is made up of judges who may not have workers' compensation experience replacing the functions of the board of review. So we would ask that if there is an intermediate court of appeals established, that it not disrupt the workers' compensation system, which has worked really well for the last 30 years. Thank you.
Thank you, Mr. Harder. Steve Broadwater, followed by Stephen New.
Thank you, Mr. Chairman, for allowing me to be here today and speak. I wanted to raise some practical issues as I oppose the bill. I am a lawyer in Fayetteville, West Virginia, although I grew up in Charleston. And after law school, I moved here, and I now own a business where we employ about 4 lawyers and 11 staff people. The practicalities of this bill, I think, don't make any sense. First of all, as it stands right now, we have a direct line to the boss. So any business, any entity thinking about moving here knows that they have a single appeal, the boss answers the phone, and they issue an opinion every single time. I don't know how you could get more consistent by adding additional judges to that system. That seems inconsistent. You're going to have different judges coming up with different opinions, whereas right now, every single case that's filed gets an opinion within 9 months in an efficient manner. This bill, if implemented, would be a wasteful expansion of bureaucracy. And the other issues I wanted to touch on was when it comes to those practicalities. What this bill does is it doubles the number of appeals in every single case. And I don't know any small business owner like me or any other business owner who wants to spend twice the time and twice the money filing appeals. The fact of the matter is we keep hearing about the 2009 report and Sandra Day O'Connor, where she had all these findings. Well, that report was based on a fundamentally different court. At the time, the court's appeals were discretionary, whereas now we get a appeal as a matter of right in every single case that's filed before them. And the numbers are completely different. The court is hearing approximately 21% of the cases it heard at the time. 3,954 were the total appeals in 2007, 2 years before the report was issued, whereas we had 931 appeals in 2019 and only 840 appeals were filed in 2020. The need for this court is no longer there. The report that came out analyzed a court that no longer exists anymore, and it may as well have been a report on California or New York. If you want a new report, fine. If you want to codify or amend the Constitution so that appeal of a matter of right is guaranteed and they can't ever change the rules, fine. But as of now, we don't need an intermediate appellate court to hear 840 cases. It can't get any more consistent than it is now. Thank you, Mr. Chairman.
Thank you, Mr. Broadwater. Stephen New, followed by Lydia Patton.
Good morning, Mr. Chairman, members of the committee. My name is Stephen New. I'm an attorney practicing in Beckley, West Virginia. I have represented workers for 23 years. Workers are the backbone of the state of West Virginia. They don't own the businesses where they work. They just run and make the money for the businesses where they work. And from time to time, they have on-the-job injuries. And the deal that was made over a century ago was that in exchange for giving up their God-given right to a jury trial, that they would be promised a quick, efficient administrative process called workman's compensation. And that's been the deal for over 100 years. And this bill, Senate Bill 275, is a slap in the face to that deal. Picking up on something that my colleague and my friend, Mr. Sean Harder, said, the Office of Judges right now is where cases are decided. 2,600 cases every year decided by 9 administrative law judges, weighing evidence and rendering decisions with findings of fact and conclusions of law. And what this bill does, this bill is going to change that process. You're going to go from 9 civil servant administrative law judges to 4 hearing examiners whose decisions will then be reviewed by a Board of Review member. There's no timeline for how long that will happen. Right now, I know from the time that my case gets submitted at the expiration of the time frame, I'm getting a decision from an administrative law judge in 30 to 40 days. This bill can't promise that with hearing examiners. The savings that this committee may think that it's going to get on the fiscal note is not going to occur. So I just ask this committee to reject Senate Bill 275. It's anti-conservative. It is not fiscally responsible.
Thank you, Mr. New. If you please wrap your remarks.
These chickens will come home to roost when litigants are no longer happy with the workers' compensation system. Tort reform has never created a single job, and this bill won't either.
Thank you very much, Mr. New. Lydia Patton, followed by Jason Huffman. Ms. Patton, you may be muted if you're speaking. Lydia Patton? I'll come back if she, let's go to Jason Huffman.
Mr. Chairman, members of the committee, can you hear me all right?
Yes, sir.
Okay, thank you for the opportunity. My name is Jason Huffman. I'm the West Virginia State Director of Americans for Prosperity, and on behalf of our activists all across the state, I encourage you to strongly support Senate Bill 275, which would finally modernize West Virginia's judicial branch of government, ensure that our citizens have robust due process protections, and address the significant shortcomings of our current judicial review process. So right now, all of our state's administrative law decisions are handled by the Kanawha County Circuit. In practice, this means that laws adopted through the thoughtful deliberative actions of this legislature, the duly elected representatives of all the people of the state, are able to be totally nullified by a single judge in a single jurisdiction. This failure of government structure is evidenced by the way of Kanawha County Circuit's decisions in recent years that have abundantly demonstrated that when it comes to questions of administrative law, certain actions of the court exist more as wrong-headed partisan judicial activism rather than good faith decisions based on sound legal reasoning. Look no further than Judge Jennifer Bailey's incomprehensible years-long delay of West Virginia's right to work law, which was passed in 2016, but because of the nakedly political actions of the court was not fully implemented in West Virginia until 2020. Now, the state Supreme Court slapped down this action way back in 2017, calling it, quote, a monumental failure of legal reasoning in which the court had, quote, abused its discretion in granting a preliminary injunction. That's because in 28 states, no state has ever struck down a right to work law. There is simply no legitimate legal rationale for doing so. Such laws have been upheld unanimously, yet Judge Bailey's delay of the right to work protections for West Virginians persisted for years after this not so subtle guidance from the Supreme Court to stop playing political games. So from the standpoint of judicial review and proper judicial review, a yearning for common sense checks and balances, this example should be wildly concerning not only for lawmakers, but for the public. It should not be the case that a single judge in a single county, sure, at the best of special interest, can use flimsy legal reasoning and a flawed power structure to usurp the decisions of the legislature. The intermediate court would take this responsibility over and end the inequitable paradigm moving forward. So I ask you to support the bill. Thank you.
Thank you very much, Mr. Huffman. Lydia Patton, are you on with us still? I want to make sure I give you ample opportunity. If you are on or muted or, okay. Well, thank you very much, ladies and gentlemen, and everybody that joined this morning, and to all the members for being here, and especially the staff for putting in a lot of hard work to make sure that we facilitated a meeting to allow, obviously, the public to be heard, which we value very much the importance of, especially in this committee. It appears to be the end of the registered individuals to speak during the hearing. And with nothing further, I'll say one more time, if you have written materials that you would like to have passed among the members of the committee, please submit those to our clerk at mark.white@wvhouse.gov, and he will make sure that the members of the committee receive those materials. With nothing more to come before the public hearing, I declare it adjourned. Thank you again to everybody for participating this morning. We will take this. Thank you.
Thank you, Mr. Chairman.